I'm delighted to be here today, and I thank Matthew for inviting me to come along. My name is Henriksen. I'm here to talk about the proposed TRIPS waiver and the effects the waiver may have on Section 7 of the TRIPS agreement, that is the protection of undisclosed information, trade secrets. A number of people today have said that a TRIPS waiver is a good thing. Might be, might not be a good thing. But in any case, everyone's agreed that it's not the final solution. It's not the only solution. But it may be a starting point. So today, I just want to give you a little bit of background on me, then I'll talk about the waiver proposal generally and the importance of trade secrets to pharmaceuticals and the pharmaceutical industry, the complementary nature of patents and trade secrets in the pharmaceutical industry. We'll move on then and talk a little bit about Section 7, Article 39, which is all about confidential information in TRIPS. So 39.1 sets up what 39 is. All about the protection of unfair competition, and then 39.2 and 39.3 talk about specifically how they're going to do that: breach of contract, breach of confidence, and then undisclosed test data. So two different types of data, I suppose, or two different types of trade secrets. I'd like then to talk about each of those individually. I'll talk about 39.3 first, data exclusivity, because it's essentially a little bit easier. When we come to it, you'll see why. And then talk about breach of contract, breach of confidence, and then conclusion or two. I want to talk particularly about pharmaceuticals today with respect to the proposed TRIPS waiver. More specifically, I'd like to talk about new pharmaceuticals. Now, whether they be small molecule pharmaceuticals, vaccinations, biologics, doesn't really matter, but new pharmaceuticals developed in response to COVID. Sorry, I'll not be talking about repurposing older pharmaceuticals or finding new solutions, new indications for old drugs around the treatment or prevention of COVID. Also, I want to look at the waiver proposal from a practical perspective. We've talked a lot about it theoretically, but let's look at how we're going to do this, and particularly how we're going to do this with trade secrets. Don't think we've considered that in enough detail just yet. So if it can be done, how can it be done, and what are the practical limitations or problems with the waiver? We need to keep in mind that while most WTO members have agreed to a waiver in principle, there's yet to be agreement on the wording of the waiver. As we all know, words are all important. This research is very early stage. I haven't got a paper on this at all. I'm just sort of clutching at straws at the moment. So as I said, my name is Henriksen. I'm a pharmacist. I've been a pharmacist for over 30 years. Actually, today marks the 34th anniversary of my conferral of my Bachelor of Pharmacy from UQ. I remember it, I'll never forget it. I've worked in community practices, both an employed pharmacist. I've owned a few pharmacies in partnership with my lovely wife. In the past, I have a law degree, and I'm currently in the final stages preparing a PhD thesis on the information exchange between biologics originators and biosimilars in Australia. And considering the information exchange between originator pharmaceuticals and subsequent entrants, that's generics and biosimilars, we've got a little bit about generics I mentioned this morning. I've considered trade secrets and their associated information exchange in the pharmaceutical industry. I work out of USC. The proponents of the TRIPS waiver assert that the objective of the waiver is to avoid barriers to timely access to affordable medical products, including vaccines and medicines, or to scaling up of research, development, manufacturing and supply of essential medical products related to COVID-19. Consideration of TRIPS Article 39 makes the wording of the text of the waiver critical in determining exactly what the proponents of the waiver wish to give timely access to. Technologies involved in the pharmaceutical manufacture, 39.2, or clinical test results of new pharmaceuticals, TRIPS Article 39.3, related to COVID-19. The proponents of the TRIPS waiver assert the objective of the waiver is to avoid barriers to timely access to affordable medical products, including vaccines. We're all well aware that patents play a crucial role in the pharmaceutical industry. Pharmaceuticals have sometimes been seen as a poster boy for patents, while trade secrets are antithetical to patents in principle due to their non-disclosure. They're still important to pharmaceuticals. It's long been noted that trade secrets and patents are complementary, especially with respect to pharmaceuticals, or can be at least. Indeed, this may be why the WTO members proposing a waiver of the TRIPS agreement sought to include trade secrets in the waiver terms. The nature of trade secret protection is the withholding of information. Indeed, to qualify as a trade secret, confidential or undisclosed information, amongst other things, the information needs to be secret. Seems to reason, really. So a waiver then would allow sharing of confidential information or a secret. Is it still a secret? A waiver in itself may not pose a problem with respect to trade secrets as such. What may pose a problem is trying to put the trade secret gene back into the bottle if, as is proposed, a waiver is temporary. Because the secret's no longer secret, as it's already been disclosed, and therefore trade secret protection no longer applies. When we talk about trade secrets in the context of the TRIPS agreement, we're referring to Section 7, that's Article 39. Section 7 is entitled Protection of Undisclosed Information and provides, first of all, that members shall protect undisclosed information in accordance with paragraph 2 and data submitted to governments or governmental agencies in accordance with paragraph 3. So 39.2 specifically protects undisclosed information that is disclosed, acquired by or used without consent in a manner contrary to honest commercial practices, such as breach of contract or breach of confidence. Article 39.3 essentially protects information provided to regulatory authorities in support of marketing applications for new pharmaceutical products. I'll talk about these two individually after I've talked a little bit about unfair competition. We know that the TRIPS agreement was put in place so that the WTO members did not have protections in place for undisclosed information, that is trade secrets, were required to do so as part of the agreement. For countries like Australia, who already had these protections in place through domestic law, a waiver may be difficult to adhere to because it seems, mean a moratorium would be placed on existing domestic laws to satisfy the waiver requirements. This is important, but let's first consider Article 39.2 and 39.3 and what these actually protect with respect to pharmaceuticals. In Australia, commercial trade secrets are generally protected by either contract law or breach of confidence actions in equity or a combination of these two. Contract law will tend to protect secret information acquired in the course of employment, during and after the employment with the commercial entities from release or sharing with third parties. Article 39.3 speaks to information provided by pharmaceutical manufacturers to governments or regulators in support of a marketing application. In Australia, this covers the Therapeutic Goods Administration, the TGA, specifically undisclosed test data. So we're talking about clinical trial results, usually, amongst other things. For today, I'll cover clinical trial results involved in marketing applications for a new pharmaceutical. In Australia, as in other jurisdictions, this type of protection is known as data exclusivity. Data exclusivity provides a limited time during which, the owner of clinical safety and efficacy trial data may rely on these data in support of a pharmaceuticals marketing application to the exclusion of others. Data exclusivity has been broadly described as a tool that recognises time, effort and economic investments made by an innovator. And in the context of biopharmaceuticals, allows the originator to recover the significant costs involved in clinical testing and originator biopharmaceutical for safety and efficacy. Same goes for a vaccination or a small molecule pharmaceutical. Consequently, data exclusivity is traditionally viewed as a benefit given to the manufacturers of new medicines to protect their investment in clinical trials. I actually think it works the other way around. When we have subsequent entrants, like generics or biosimilars, provided that they can prove that they're essentially the same in safety and efficacy as the originator, after the prescribed data exclusivity period, they can use the originator's clinical trial data. It costs them nothing. They don't have to see it, they don't have to handle it, but they can rely on it for their marketing application. Saves them a whole lot of time and money in clinical trials. It's a good thing. So, I don't think it's a benefit to the originator. The benefit comes to the subsequent entrant. Data exclusivity is a good thing in my view. So I've already talked earlier about what data exclusivity is. In Australia, it's legislated through the Therapeutic Goods Act, Section 25A. This section of the Therapeutic Goods Act in practice says that clinical trial data used in support of a marketing application for a new pharmaceutical cannot be used, for a period of 5 years for anyone else from when that pharmaceutical is entered in the Australian Register of Therapeutic Goods, the ARTG. The use of protected information referred to here is for a subsequent entry to rely on that originator clinical data. However, after the 5 years has elapsed, as I said, any subsequent entrant can use that. Not all jurisdictions have the same time period. Some longer, none shorter, as far as I know. So, what does a TRIPS waiver mean in respect of data exclusivity? A TRIPS waiver on data exclusivity means that the subsequent entrants get to use the originator clinical trial data sooner, perhaps. But if the waiver comes to an end, it's conceivable the subsequent entrant can no longer rely on the originator, but the subsequent entrant has already been granted marketing approval. What happens then? We've got competition in the market. They've used that data to get their marketing application. Does the marketing application get withdrawn? Or do we just say, you used it now, it's fine, you're on the market, we'll just keep it? So no longer is there a 5-year data exclusivity period, conceivably. This also means that the waiver with reference to data exclusivity does not help the first pharmaceutical to market. In a practical sense, the Therapeutic Goods Act, Section 25A, can be frozen and then re-enlivened, in theory, in practical. Overall, it might work. What about Section 39(2)? Breach of confidence, breach of contract. A waiver might be problematic from the point of view that it's envisaged as temporary. This suggests that the relevant sections of the TRIPS agreement will be re-implemented at a later date. We've talked about 3 years. Annual reviews might go on forever, might go on for 3 years, might go on for 5. Current proposal advocates 3 years with a moratorium on annual reviews. So breach of confidence actions might be more difficult to encompass in a waiver for a number of reasons. First of all, can you suspend breach of confidence actions? That is, can you suspend equity? If it was fair yesterday, if it was unfair yesterday, it's probably the same today. Employment contracts will become involved in the waiver, in that non-compete clauses will be captured by the waiver. There's a whole lot of contracts out there that will be captured by this. If breach of contract is argued in litigation, there may be a defence of, I did that during the TRIPS waiver period. As I noted at the beginning of this talk, trade secrets are often used in conjunction with patents in the pharmaceutical industry. For example, it might be advantageous to patent a particular pharmaceutical molecule, and in so doing provide disclosure of the best method to perform that molecule, but the exact details of the manufacturing processes may be kept secret. In these cases, trade secrets act as an effective monopoly creator in their own right. There is an important safety valve in trade secret monopolies, which may or may not be relevant, and that's this idea of reverse engineering. If you can reverse engineer something, it doesn't mean that you've breached the trade secret, provided you haven't used that trade secret information to reverse engineer it. For example, it might be, this may not be the case, of course, if the information has been imparted according to the 3 conditions mentioned earlier, a secret of commercial value that has been imparted in conditions of secrecy, and the secret holder has tried to keep it confidential. However, if you're not the person receiving the secret information, you may be able to reverse engineer the pharmaceutical without fear. One of the strengths or problems, depending on how you look at it, with trade secrets is that they have the potential to last forever. That is, they last as long as they're secret. The way I see it, this is a major problem with the waiver. Once a secret is no longer secret, the ability to put the genie back in the bottle is gone. Can't do it. Further, if the secret is in the public domain, it would be difficult to elicit protection afforded by a breach of confidence action. Indeed, the requirements of an action in breach of confidence become irrelevant. I've got a little case study provided to me by Matthew, and I must say that I appreciate that. It's a very recent case filed in the United States. Pfizer incorporated against Chun Xiao Li, filed on 23rd of November, so very recent. Ms. Li was an employee of Pfizer since 2006, initially in China, and then in 2016 she transferred to Pfizer's California facility. The complaint of Pfizer focuses on the Pfizer COVID vaccine and 2 monoclonal antibodies that they were under development, or they have under development. So it alleges that Ms. Li misappropriated over 12,000 documents, all of which were secret in nature and may cause detriment to Pfizer's business. Through all the documents, the court documents, you can see that it says that. Interestingly, Ms. Li's alleged misappropriations led to Pfizer litigation under 5 separate causes of action for the same set of circumstances. First of all, trade secret misappropriation. Second cause of action, trade secret misappropriation, different forum, but presuming one is federal law, one is state law, California. Third, breach of contract. 4 and 5 are very interesting. Pfizer alleged conversion. In Australia, it may also be debt if we were talking about Australia, because they'd asked for the documents back and she said, no, I haven't got them, you're not getting them. Or I've given you everything I have. And they've also argued trespass to chattels, trespass to goods in Australia. So misappropriation can be argued in Australia in similar actions. This suggests that a waiver on TRIPS Article 39 may not achieve the desired outcome, as even without actions available in breach of contract or breach of confidence, a plaintiff may still be able to argue conversion and trespass to goods. That makes a waiver a little bit irrelevant. It'll be interesting to see how this plays out, and particularly the actions of conversion and trespass to chattels, as I said. It's maybe relevant to a TRIPS waiver consideration. From a practical sense, it would be difficult to advocate a suspension of this particular article of TRIPS because, using the Pfizer example, other options of litigation may exist, so the suspension of Article 39 may be ineffective. Pharmaceutical companies will still want to protect their intellectual property, and they'll find ways to do so. That's what they do. So in conclusion, or the conclusion that I've come to this early in the piece, a moratorium on enforcement of TRIPS Article 39 may make sense in principle. However, proponents of the TRIPS waiver assert the objective of the waiver is to avoid barriers to the timely access to affordable medical products, including vaccines and medicines. In practice, switching off the relevant domestic law related to Section 7 of the TRIPS agreement may be difficult. For example, as I said earlier, breach of confidence actions in Australia are based in equity. How can you switch that off? However, even if you can switch off the relevant laws, this may not be as difficult as switching these provisions on again. Here I speak of trade secrets in the public domain. They're no longer secret, and they never will be again.